Missouri has a landlord-friendly tenant screening environment with minimal state-level regulation beyond the federal baseline. The governing framework includes Missouri's landlord-tenant statutes, found in Missouri Revised Statutes Chapter 441, along with FCRA and the Missouri Human Rights Act. Missouri gives landlords broad discretion in the screening process, though landlords in Kansas City and St. Louis need to be aware of local provisions that add requirements beyond state law. Let's start with application fees. Missouri does not cap application fees. There is no state statute limiting what a landlord can charge for tenant screening. Missouri's landlord-tenant statutes do not address application fee amounts, procedures, or refund requirements. Landlords can charge whatever they determine is reasonable. Most Missouri landlords charge between $25 and $50 per applicant. Missouri's rental market is generally affordable, and keeping fees proportionate to actual screening costs is good practice. In competitive markets like downtown Kansas City and certain St. Louis neighborhoods, applicants are accustomed to paying fees. But in more affordable markets across the state, excessive fees can discourage qualified applicants. Criminal history screening in Missouri is largely unrestricted at the state level. Missouri does not have a comprehensive statewide ban the box or fair chance housing law. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can use criminal history as a screening factor without conducting a formal individualized assessment, and are not subject to state-mandated look-back period limits. However, Kansas City enacted a local ordinance that affects criminal history screening. The Kansas City Human Rights Ordinance and related tenant protection measures include provisions that restrict how landlords can use criminal history in housing decisions within the city. Kansas City has been at the forefront of tenant protection in Missouri, and landlords operating within the city should review the current ordinance for specific procedural requirements, including any restrictions on the timing of criminal history inquiries and individualized assessment mandates. St. Louis has also been active in discussing additional tenant protections. The city's political environment supports further regulation, and landlords in St. Louis should monitor local ordinances and policy developments. Outside Kansas City and St. Louis, the criminal history screening landscape is unrestricted. Springfield, Columbia, Independence, and every other Missouri community outside the two major cities operate under the same permissive framework. Missouri has a preemption statute, Section 441.043, that limits the ability of local governments to regulate certain aspects of the landlord-tenant relationship. However, the scope of preemption as it relates to screening specific ordinances has been subject to interpretation. Kansas City has argued that its ordinances fall within its authority despite preemption, and the interaction between state preemption and local tenant protections remains an evolving area of Missouri law. Landlords should stay current on how this tension is being resolved. Missouri has expanded its expungement provisions in recent years. Under Section 610.140, certain offenses are eligible for expungement after specified waiting periods. Once a record is expunged, the individual is treated as if the offense never occurred, and landlords cannot consider expunged records in screening decisions. Missouri's expanded expungement eligibility means that more records are being cleared over time, and screening providers should be filtering expunged records from reports. Missouri decriminalized marijuana possession in certain amounts and legalized medical marijuana, and voters approved recreational marijuana through a constitutional amendment. Landlords should be cautious about using marijuana-related records as a basis for denial, particularly for conduct that is now legal under Missouri law. The legalization landscape has shifted rapidly, and screening criteria should reflect current law. HUD's 2016 guidance on criminal history and disparate impact applies in Missouri. Kansas City and St. Louis both have diverse populations, and criminal history policies that disproportionately affect minority applicants face scrutiny under federal fair housing law. Missouri's major cities have active fair housing enforcement. The Kansas City Human Relations Department and the St. Louis Civil Rights Enforcement Agency both investigate complaints. Documenting your criteria and applying them consistently is essential. Source of income protection in Missouri varies by jurisdiction. Missouri does not have a statewide source of income protection law. Landlords outside protected jurisdictions can consider the source of an applicant's income and can decline voucher holders. However, Kansas City enacted source of income protections as part of its local human rights ordinance. Landlords in Kansas City cannot reject applicants solely because they pay with housing choice vouchers or other government assistance. The Kansas City Human Relations Department enforces this protection and investigates complaints. St. Louis has also been active in discussing source of income protections. Landlords in St. Louis should monitor local developments outside Kansas City and any other cities that enact local protections. Source of income discrimination is not prohibited by state law. Participation in voucher programs is voluntary for landlords in unprotected jurisdictions. For credit reports, Missouri follows standard FCRA requirements, permissible purpose, written consent, and adverse action notice procedures. Missouri does not impose additional state-level requirements for credit report access, adverse action content, or notification timelines beyond FCRA. Missouri's fair housing protections under the Missouri Human Rights Act, found in Chapter 213, prohibit discrimination in housing based on race, color, religion, national origin, sex, disability, and familial status, mirroring the Federal Fair Housing Act. Missouri has not added additional protected categories such as sexual orientation, gender identity, marital status, age, or source of income at the state level. The Missouri Commission on Human Rights investigates fair housing complaints. Kansas City and St. Louis have both enacted local non-discrimination ordinances with broader protections. Kansas City's Human Rights Ordinance includes protections based on sexual orientation, gender identity, and source of income. St. Louis has similar local protections. Landlords in these cities must comply with the broader local requirements. Screening decisions that appear to target applicants based on locally protected characteristics can result in enforcement actions. Columbia, home to the University of Missouri, has also enacted local non-discrimination provisions that include sexual orientation and gender identity protections. Landlords in Columbia should be aware of the local ordinance. From a practical standpoint, Missouri has a large rental market with 2 major metros and several significant secondary markets. Kansas City, straddling the Missouri-Kansas border, has the state's most dynamic rental market. The Missouri side of the metro, including Kansas City proper, Independence, Lee's Summit, Blue Springs, and Gladstone, has a diverse economy driven by healthcare, including the University of Kansas Health System, St. Luke's Health System, and Children's Mercy, technology, financial services, federal government, including a significant IRS and GSA presence, logistics, and automotive manufacturing, including the Ford and General Motors plants. The Kansas City Metro has experienced moderate rent increases and steady demand. Kansas City's screening environment is the most regulated in Missouri due to the city's local ordinances, including criminal history restrictions and source of income protections. Landlords in Kansas City must treat the city's requirements as their compliance baseline. The Kansas City Human Relations Department actively investigates complaints and takes enforcement action. The Country Club Plaza, Crossroads, Westport, Brookside, and Waldo neighborhoods have strong rental demand from young professionals. The Northland communities, including Gladstone, Liberty, and Parkville, attract families. East Side and South Side neighborhoods have more affordable rents and higher concentrations of tenants receiving housing assistance. Fort Leavenworth, across the border in Kansas but serving the Kansas City Metro, and Whiteman Air Force Base southeast of the city generate military rental demand that extends into the Missouri side of the metro. Military tenants' income is documented through leave and earning statements and BAH rates. St. Louis has a complex rental market shaped by the city-county divide and decades of demographic shifts. The city of St. Louis is an independent city separate from St. Louis County, and the two have different regulatory environments. The city's economy is driven by healthcare, including BJC Healthcare, SSM Health, and Washington University Medical Center, higher education, Washington University and St. Louis University, financial services, defense, including Boeing's St. Louis operations, and manufacturing. The city of St. Louis has seen revitalization in neighborhoods like the Central West End, Tower Grove, Shaw, Soulard, and the Cortex Innovation District. These neighborhoods have strong rental demand and rising rents. However, other parts of the city face population decline and vacancy, creating a highly varied market within a single municipality. St. Louis County, including Clayton, University City, Kirkwood, Webster Groves, and Chesterfield, has a more suburban market with diverse pricing. The county operates under state law rather than the city's local ordinances. Columbia, home to the University of Missouri, has a tight, student-driven market supplemented by healthcare, including MU Healthcare, and state government operations. Mizzou's large enrollment creates enormous seasonal demand and high volumes of applicants with limited credit and rental history. A consistent cosigner or guarantor policy is essential for Columbia landlords. Springfield, in southwestern Missouri, has an affordable market driven by healthcare, including Mercy Hospital and Cox Health, education, Missouri State University, Drury University, and Evangel University, and Bass Pro Shops World Headquarters. Springfield's market is moderate with steady demand. Joplin, Jefferson City, Cape Girardeau, and St. Joseph have smaller markets with varying demand levels. Jefferson City, the state capital, has a stable, government-driven market. The Lake of the Ozarks area has a seasonal tourism market with workforce housing demand during the summer season. Fort Leonard Wood, in the central Missouri Ozarks, is a major Army installation that generates significant military rental demand in the Waynesville, St. Robert, and Rolla communities. Military tenants represent a large portion of the local rental market. BAH rates for the Fort Leonard Wood area are modest, and landlords near the base should understand military income documentation and the deployment cycle that creates regular turnover. Whiteman Air Force Base near Knob Noster generates military rental demand in the Warrensburg and Sedalia areas. BAH rates for the Whiteman area are moderate. One best practice for Missouri landlords: determine immediately whether your property is in Kansas City, St. Louis, Columbia, or another municipality with local screening restrictions. Build your screening process around the most restrictive rules that apply to your specific location. If you own properties in both Kansas City and a suburban community outside the city limits, you may need different procedures. Kansas City's criminal history restrictions and source of income protections don't apply in unincorporated Jackson County or other suburban communities outside the city. Another best practice: verify that your screening provider is current with Missouri's expanded expungement provisions and marijuana legalization. Records that have been expunged should not appear on reports, and marijuana-related records for conduct that's now legal should be evaluated carefully. Ask your provider specifically about their compliance with Missouri's expungement statute and how they handle marijuana-related records in the context of legalization. A third best practice: for landlords in Kansas City, never state in any form that you don't accept vouchers or government assistance. Kansas City's source of income protection is enforced by the Human Relations Department, and fair housing testing occurs. Remove any language from listings, websites, or policies that suggests you don't accept Section 8. Train everyone who handles inquiries or applications that source of income discrimination is prohibited within the city. Missouri limits the security deposit to 2 months' rent. The deposit must be returned within 30 days of the tenant vacating. If the landlord fails to return the deposit or provide an itemized statement of deductions within 30 days, the landlord may be liable for up to twice the amount wrongfully withheld. The 2-month deposit cap provides moderate financial protection, but thorough screening remains the most effective approach to tenant selection. For the complete guide to Missouri tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.